In today's political climate, can there be any more of a defamatory accusation than being called the R word?
Russian asset.
I mean, technically that's RA, but that's also research assistant, and nobody minds being called a research assistant.
Except for professors.
It's vlog time. I am Viva Frei, a Montreal litigator turned YouTuber, and I do these things called vlogs where I break down and explain something that's going on in the legal world in terms that can be understood by everyone. And recently, the news has been giving us great catalysts to discuss a number of legal issues, but in particular, defamation has been coming up a lot these days, and today is no different. For those of you who don't know, Hillary Clinton recently gave an interesting interview where she referred to Jill Stein as a Russian asset, and also stated that the Russians were grooming a current candidate of the Democratic field. And for those of you who have not yet heard that interview, here is the audio of that interview.
But I think they've got their eye on somebody who's currently in the Democratic primary and are grooming her to be the third-party candidate. She's the favorite of the Russians. That's assuming Jill Stein will give it up, which she might not, because she's also a Russian asset.
Now, an important observation that we will get back to by the end of this video. Hillary Clinton does in fact mention Jill Stein by name, but she doesn't mention anybody in the Democratic Party by name. Although she was referring to a she, which limits the choices, and by all accounts she was referring to Tulsi Gabbard. Now, I first saw the story on Fox News, and because I take everything with a grain of salt and some things with a bigger grain of salt, I had to go independently verify this myself, and lo and behold, the interview was given and the words were spoken. And in today's day and age, where the worst thing you can probably be called is a Russian asset, everyone's asking, why doesn't Tulsi Gabbard sue Hillary Clinton for defamation? Why doesn't Jill Stein sue Hillary Clinton for defamation? I've done a bunch of videos on defamation, and I'll link the playlist right up here. But this is always an interesting question, and there have in fact been some recent developments in the Supreme Court that make this question even more pertinent. Defamation breaks down into two broad categories, libel and slander. How do you remember this? Libel being literary, as in written, slander being spoken, hence the alliterations to help anybody remember. Defamation, at least under US law, is the publishing of a false statement that damages the reputation of the object of that statement. In Canada, it's pretty much the same thing, with the caveat that in Quebec, defamation can occur even if the statement is true, if it is spoken with the purpose and objective of damaging someone's reputation. Now, I know a lot of you find this concept particularly offensive, but it is in a way nothing more than an extension of the public disclosure of a private fact, although it is still offensive to people who believe in the utmost freedom of speech, and I totally understand that. Defamation, making oral or written statements that are false that damage the reputation of the object of those statements. And in the context of defamation, we need to look at the object of the defamation because they are treated differently depending on who they are. You have private citizens, public figures, and limited purpose public figures. And the distinction, although a construct of the Supreme Court of the United States, is paramount. The burden of proof, or the threshold in order to succeed on a claim for defamation, is not as high for a private citizen as it is for a public figure. Private citizens, meaning people who do not live in the public eye, need only prove that the statements were false and they damaged their reputation. The situation is different, however, for public figures and limited purpose public figures, and this in virtue of a Supreme Court decision in 1960. New York Times versus Sullivan. In that decision, which actually reversed the two previous lower court decisions, it was decided that a public figure and a limited purpose public figure, in order to succeed on a claim for defamation, need not only prove that the statements were false and damaged their reputation, but that the statements were made with actual malice. Sorry, I think I spat a little there. Actual malice. And what is actual malice? It means that the person who made the statements knew that they were false or made them with reckless disregard for the truthfulness of those statements. And a brief summary of the New York Times versus Sullivan Supreme Court decision. It is a 1964 decision that reversed the two previous lower court decisions. In that case, civil rights activists ran an ad in the New York Times that was critical of the Montgomery police handling of civil rights activists. The ad was a full one-page ad and apparently contained a number of material inaccuracies as to what actually happened. The Montgomery Police Commissioner, Montgomery, Alabama, incidentally, the Montgomery Police Commissioner, Sullivan, sued the New York Times for defamation as a result of having run the ad, which contained defamatory inaccuracies. The trial judge agreed that the advertisement was defamatory per se, and a jury awarded Sullivan the full $500,000 that he was claiming. All right, first, and I think only parentheses of this video, defamation per se. What does the per se add to the defamation? You have two types of defamations. You have defamation per se and defamation per quad. Defamation per se is defamation that is defamatory on its face and requires no extrinsic evidence or additional information in order to interpret the defamatory nature of the statements. Defamatory per quad, on the other hand, means that the statements were not defamatory on their face and require external evidence or additional information in order to understand and appreciate the true defamatory nature of those statements. All right, back to the video. New York Times appealed the decision to the Supreme Court of Alabama, who confirmed the lower court's decision. Enter the Supreme Court, and they reversed the decision a full 9-0. The Supreme Court unanimously came to the conclusion that when dealing with public figures or limited purpose public figures, and we're going to get to this in a second, in order to preserve the freedom of the press, it's not enough to prove defamation. They need also prove actual malice. It's worth noting that before this 9-0 decision, there was something like $300 million in outstanding libel suits pending against media organizations for defamation, libel, and slander. This 9-0 Supreme Court decision presumably resolved a lot of those outstanding lawsuits by increasing the burden of proof to the requirement of proving not only the defamation, but that the statements were made with actual malice as relates to public figures and limited purpose public figures. Agree or disagree with it? At the very least, now you know. And public figures versus limited purpose public figures is very interesting a distinction as well. Private citizens do not live in the public limelight, and as such, they are not subject to public scrutiny. Public figures, however, live in the public limelight. They are celebrities, politicians, people who deliberately live in the public light and are therefore subject to more public scrutiny. Limited purpose public figures are people who are either voluntarily or involuntarily thrust into the public spotlight on specific issues or specific events. For example, private citizens who become spokespersons on specific important issues, or private citizens who unwillingly find themselves in certain very public situations, public events that garner media attention. People who get accused of very serious crimes, people who go on racist rants in coffee shops, victims who come forward to press charges and or sue their accusers. And it's in this last example that the court construct of actual malice has come back to the juridical fore. One of Bill Cosby's accusers recently sued Bill Cosby for defamation because apparently Bill Cosby, through his attorneys, sent a letter to media organizations for publications, and apparently the letter contained defamatory statements as relates to the history of the accuser. Her lawsuit was tossed on the basis that she had become a limited purpose public figure, and therefore the defamation had to have been made with actual malice. And Supreme Court Justice Clarence Thomas was recently very critical of this precedent set in New York Times versus Sullivan, which he described as a largely judge-made rule of law. All right, last parentheses, I promise. This is the lawsuit where Catherine May McKee was suing Bill Cosby for defamation. Her lawsuit was initially tossed, and there were appeals, and they ultimately asked for leave for permission to the Supreme Court of the United States, who refused to hear the case. Judge Clarence Thomas, however, wrote in his 14-page concurring opinion that he was critical of the precedent set in New York Times versus Sullivan, and that it might be time to revisit this given the age of modern media and internet and stuff like that. Okay, kids are coming in. Back to the video, ending the video. Actual malice as a criteria for public figures or limited purpose public figures to succeed on a claim of defamation did not exist in the Constitution, and it was the courts that created it in New York Times versus Sullivan, arguably in response to a slew of defamation lawsuits that were pending in the order of $300 million in 1960s dollars. And so how does all of this circle back to Hillary Clinton calling Jill Stein and an unnamed Democrat running for president as Russian assets? Defamation. Let's just operate on the basis that Hillary Clinton was in fact referring to Tulsi Gabbard. Jill Stein and Tulsi Gabbard are public figures pretty much by definition. Tulsi Gabbard even more so, to the extent that she's actually running for president right now. They are therefore subject to the actual malice criteria of the defamatory statements. Ultimately, under the current state of the law, actual malice is, if not virtually impossible to prove, very, very difficult to prove. And another thing is that defamation doesn't apply to statements of opinion. Some might say that referring to Jill Stein and presumably Tulsi Gabbard as Russian assets is a pure matter of opinion and therefore cannot constitute defamation. And I might tend to agree with that, but even if it were made as a pure statement of fact, Jill Stein and Tulsi Gabbard would have to prove that the statement was made with actual malice. And as relates to Tulsi Gabbard, it's even more complicated because Hillary Clinton never mentioned her by name. So it's not clear that it could be defamatory as relates to Tulsi Gabbard because she was not specifically mentioned. And recall from my video discussing the dismissal of Nicholas Salmon's lawsuit against the Washington Post, this was in fact part of the reasoning of the judge, that the allegedly defamatory articles didn't actually mention Nicholas Salmon by name, and they were therefore not of and about Nicholas Salmon. Some people might even argue that it would be an inculpating assumption for Tulsi Gabbard to think that Hillary Clinton was talking about her as being the Russian asset that was being groomed within the runners for president in the Democratic side. But operating on the current basis of the law, and even more recently the decision that dismissed Nicholas Salmon's lawsuit against the Washington Post, to the extent that Hillary Clinton did not specifically mention Tulsi Gabbard, would be a very big defense against any claim for defamation above and beyond the proof of actual malice. And almost more important than any of this, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below, share my channel with someone who you think would appreciate it. If you want some merch, the links are always below. If you want to support the channel, PayPal link is somewhere up in the banner here and in the comment section below. And now you know your vlog. Peace out. Booyah!